A recent case from a federal court in Oregon is a great reminder of the rules on defamation cases.
This is Dr. David Shine, and welcome to Business Law 101.
The background on this case is interesting. Jonathan Tallman owns and operates a coffee shop in a small town in Oregon. In 2019, he had a 16-year-old girl working there, Michaela Miller. Her opinion was that Tallman, engaged in inappropriate conduct with her when others were not present. She was involved in high school sports, and she discovered other teammates had experienced similar harassment at the coffee shop. A school coach overheard and, being a mandatory reporter, reported it to the police. The police took statements but did nothing more. Eventually, she quit the job. Starting in 2020, Tallman was an unsuccessful candidate for local office, get this, 4 consecutive years. In August of 2023, a local individual either posted or shared the police report on Facebook. Shortly after, Ms. Miller responded on Facebook with her own posting and later posted it elsewhere. 1 month later, in September of 2023, Tallman sued Miller in state court, asserting Oregon common law claims of defamation, defamation per se, and false light invasion of privacy. Miller timely removed the case to federal court and then filed a motion to strike Tallman's case. A federal magistrate, however, agreed with Tallman. Now, that's a first-level court. You can take the decision or you can ask for a regular judge to hear the case. That's what happened here. Miller then asked the district court judge to consider the case. The district court cited 1964 SCOTUS case, famous case, New York Times versus Sullivan. In short, for a public figure to be defamed, he or she must prove the false and defamatory statements were published with actual malice, i.e., knowledge of falsity or reckless disregard of the truth. So the question is someone who has not held office, but a recent 4-time candidate, a public figure? The court ruled in this case that Tallman indeed was a public figure. Therefore, he would face a much higher level of proof to prevail in the defamation case. The district court judge went on to indicate that perhaps if Tallman had not been a recent candidate, but decades later the case arose, then the case might be decided differently. This is Dr. David D. Shine for Business Law 101. If you've enjoyed this episode, please subscribe on your favorite platform.